issues with housing, we really have to confront the legacy of decades of racist housing policy.
Everyone might want to mute your microphone if we're not making a presentation. Our video is starting and we are going live. Thank you very much.
To move money from brown people to white people, and
okay,
really got it.
Thank you. Awesome. Right. Do we have a quorum, Anna?
Let me consult with John and I will let you know in 1 moment.
Yes, let us know, and as soon as we can start, we will.
Chair Long, we do have a quorum for both Camarillo and Oxnard.
Oh, fabulous. Thank you very much, Anna. With that, then, it is 7 o'clock exactly, and we will call the Airport Authority meeting to order. So if we can, we'll start with the Pledge of Allegiance. And Mr. Calhoun, if you could start us off, that would be wonderful.
Hopefully you're everyone ready? Please pledge of allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you.
Thank you very much. Next up is our roll call. Anna, please lead us.
For Camarillo Airport Authority, Supervisor Long.
Yes.
Supervisor Ramirez is running late. Vice Mayor Molche.
I am here, present.
Thank you. Councilmember Santangelo.
Here.
Bill Thomas.
Here.
Mike Hodson.
He is here.
He's here. I saw him, but he's on mute.
Okay.
That's
just for the public's knowledge.
Mike,
Okay,
we
Mike.
can see you, but we can't hear you. We can see you talking, but we can't hear you. Okay, there's a quorum for Camarillo and for Oxnard.
Supervisor Long.
Yes.
Supervisor Ramirez is running late. Councilmember Perallo.
He's here.
Councilmember, I believe you're muted. We see you, so I will mark you as present. Councilmember Lopez.
Here.
Thank you. Walter Calhoun.
Here.
Eugene Fussell.
He's here.
Fussell is here.
Thank you very much. Oxnard has a quorum.
Thank you very much. So everyone is in attendance. Next is the approval for the minutes for the Camarillo Airport Authority. Can I get any discussion, or I'll take a motion?
Bill Thomas, I move approval for the minutes from February.
Thank you very much.
Sean Molche, I'll second.
Thank you. So it's been first by Mr. Thomas and second by Councilmember Molche. Any other discussion? Roll call, please. Or
Supervisor
can I just?
Long.
Yeah. Yes.
Sorry. Vice Mayor Molche.
Yes.
Councilmember Santangelo.
Yes.
Bill Thomas.
Yes.
That motion passes unanimously.
Thank you. And I'll pass it to you, Mr. Calhoun.
May I have a motion on this, please? Also motion. Is there
I'll motion to approve the Oxnard minutes. Long.
Second from Lopez.
Oh, you hear me? Okay, we have a motion and a second. All those in favor? Aye.
Anna, do we have to do a roll call on this, or can we all say aye?
You can say aye, and if Chair Calhoun calls for abstentions afterwards, that would be fine.
Cool.
Yeah.
Aye.
Did you hear the call for the aye?
Aye.
Aye. All those
Any-
opposed? Hearing none, motion so carries.
Thank you.
Is there any abstentions? None? Great. Okay, public comments. Are there any public comments?
No written comment?
Okay. And, all right, so any unfinished business? None. So we'll go to new business. And the new business is our Camarillo and Oxnard Airport Authority. I do want to make sure there's probably a lot of speakers. I don't see them as of right now. But you will have 3 minutes for your public comments. Wanted to let everyone know. And when we call your name, you'll come on and unmute yourself and then we'll start. So I'll turn this over to Mr. Turner.
Thank you, Madam Chair and Chair. We've got a small presentation to open this discussion up. So if I could maybe get through that, and then I've also asked our county council to speak on a particular item in relation to the presentation of this, and then we'll open up for questions and discussion during that or after that. Excuse the glasses, my eyes are getting a little worse. Since 1985, the Department of Airports has been using the same form to lease and to land to private owners of aircraft storage hangars at the 2 Ventura County airports. That form is outdated and no longer meets the department's needs. Beginning in 2015, prompted in part by tenants' request to be able to sublease their hangars, in part by concerns over tenants' uses of the hangars, and in part by various inadequacies of the current lease form, the department has been attempting to update the lease form. Efforts have included obtaining the help of a third-party facilitator, meetings with a committee of various stakeholders at the county's airports, 2 town hall style meetings, numerous workshops, presentations, and meetings with tenants and hangar tenant association groups, and discussions at the Aviation Advisory Commission and Camarillo and Oxnard Airport Authorities meetings. A great deal of time, energy, and funds have been spent on this process. Those efforts include a staff proposed private hangar lease that was presented for consideration 1 year ago in the March 2020 regularly scheduled commission and authorities meetings. At that time, staff was requested by the authorities to further review and report back on 6 sections of the proposed agreement based on discussion during their meeting. And if I could get staff to go to that slide of the 6 sections, please. As you'll see here on the presentation, the first section was section 1, and that was revised to remove the pilot's license number. And then the next one was section 10, and it was revised to allow 1 car and 1 golf cart in all hangars, and to allow 2 cars and 1 golf cart if the hangar is over 1,500 square feet. The third one was section 26, which is now in the new proposed lease known as section 27. And we were not able to satisfy that request, so that was declined. The fourth one was section 35, which is now 36 and 37, which was revised to split assignment and subletting into 2 sections as requested. The 5th one was section 38, which is now section 39, and it was revised to remove minor violation. And then the last one of the 6 that we were asked to come back on was section 46, and we deleted that one altogether as requested. A revised draft of the proposed lease agreement was sent out on February 1st, 2021 in a mass email including all private hangar owners, CAHOTA representatives, authority and commission members, county leadership, and others with an interest in this agreement, seeking additional comment and feedback. Staff hosted a virtual meeting on February the 11th with all interested hangar owners to receive feedback and address questions and concerns relating to the proposed agreement. Staff received numerous emails and calls after the current proposed lease was sent out. All calls and emails received up until the virtual meeting were responded to within 24 hours by the director. All calls and emails received following the virtual meeting were responded to if they were addressing new information. Certain feedback received throughout this process led to new edits, which were all in favor of those requests received. This item was scheduled for discussion and consideration during the March 2021 Commission and Authorities meetings. and then finally for the Ventura County Board of Supervisors on March 23rd. These public meetings are in addition to the many opportunities previously provided for tenant and public participation. The current proposed lease is the same proposed lease that was sent to the tenants on February 1st, with exception to 3 sections. These 3 sections were later edited based on the comments and or concerns received following the lease going out to the tenants on February the 1st. The edits are illustrated in Exhibit 2 of your packet in track change format for easy reference. And we've also got that pulled up on the screen here. And I'd like to just go over those edits that were made since February the 1st when this went out, again, based on feedback that we received from our tenants. And you'll see there in section 19 of the lease under insurance, the terminology for new hangar was better defined. So new hangar is only for a new hangar being built after this, not for a current hangar, and is only for a new tenant. So, and then section 19B, the airworthy aircraft insurance. Our first request were for us to lower that to 500,000, which we did. That was the first action we did, and then we continue to have feedback from our tenants that even that might be difficult. So we just removed that altogether. We took that out. So it started at $1 million, and now it's totally taken out. The next item, if staff would roll back, please. Whoa, staff. 19G, we added 30 days upon request of change of insurance. That was a request from our tenant base to put in within the 30 days. And then if you can scroll down to 25, I think it is. You'll see here in repair and maintenance of premises, our requests that came in on this were concerned about the number of years we had put in there for repainting the hangars. So again, we felt that was something that was we could cover in other ways if we needed to, and without having to be specific to the 8 years. So we took that out per the request of the tenants. And then if you could scroll down to 40, what was, or 39 now, go ahead. And this 39 is, or what is now 39, is the language that we needed to keep out of 41, but we did get rid of the immediate termination clause in 41. The proposed lease being discussed now is the culmination of a 7-year effort and provides a lease that adds, improves, or clarifies numerous provisions, including lease term, assignment and subleasing, storage of additional aircraft, storage of non-worthy aircraft, storage of a motor vehicle, storage of other non-aeronautical items, relocation of the hangar, default notice procedures, maintenance of the hangar, utilities, trash, airport security, fire hazards, and termination expectations. The revisions also remove obsolete requirements, reflect current requirements and practices, and conform to other county airport lease agreements in format and content. The proposed lease, revised lease, is intended primarily for existing private hangar owners, however, will also serve as a template for new private hangar owners. In short, this proposed lease offers much greater clarity and flexibility for tenants than the existing lease. And if staff could pull up the lease comparison slide. As you'll see here in the lease comparison slide that we've got in front of you here, the current lease was more designed for relocatable aircraft storage hangars only, whereas the new proposed lease covers any type of private storage hangar. The term of lease went from a 30-day lease in the current lease up to 20 years. So a lot more protection and for the tenant. The termination clause went from an immediate termination clause for pretty much anything to now it's only a shorter notice for criminal act breaches only, with everything else getting 30 days or more. Transfers and assignments are not allowed in the current lease that exists today, but they are allowed for transfer and assignment in the new lease. The change of ownership requirement of notice went from a 10-day notice for aircraft change of ownership or substitution to a 30-day notice. The aircraft replacement went from a 90-day period, allowable period, up to a 6-month period. The ability to sublet the hangar is not allowed in the current existing lease. However, it is allowed in the new proposed lease. The transfer fees that apply today in the existing lease, we have already gone to the Board of Supervisors, and the Board of Supervisors approved a waiving of those hangar transfer fees for existing hangar owners that enter the new lease before June 30th, 2021. And we anticipate maybe even going back to the board to try to get that extended. The additional stored aircraft is not allowed in the existing lease, and however, it is allowed in the new lease. And then the last two items, the aircraft under construction is not allowed in the existing lease, although it is allowed and authorized in the new lease. And the final one there in the graph that we show here is the allowable items in the hangars. According to the existing lease, it's very restrictive, and it only is pertaining to aeronautical items. We have very much loosened that in the new lease for allowed storage inside the hangar to where pretty much can be stored, anything can be stored in there as long as it doesn't interfere with an active aircraft. The commission most recently reviewed this item at the advisory commission, the Airport Advisory Commission, most recently reviewed this item at its March 1st, 2021 meeting, week before last. The commission did not vote on a recommendation to the County Board of Supervisors. Instead, 6 members of the commission recommended that department staff meet again with hangar owner representatives to again discuss concerns already raised and addressed by the department and return this item to the commission no later than June. However, as the department informed the commission that the hangar owner's concerns have been previously received and reviewed by department staff, and appropriate changes have already been made to the form lease, the department now believes that staff has exhausted all efforts to revise those items and that the current lease proposal represents the best balance between the tenants and the county's interest. There have been numerous questions and or concerns specifically related to Section 39 of the proposed lease agreement. I have asked County Counsel Tom Temple in these opening remarks to address the legal questions particularly related to Section 39 at this time. So if we could give the mic to Tom Temple, please.
Good evening, everybody. Tom Temple, as Kip said, from County Counsel's office. Section 39 of the current proposed lease has drawn a lot of comments, and my office has taken a look at all of those. And when we were last in front of this body back a year ago, the version of this provision is the one that you see on the screen now in the middle of the screen, the February 2020 version. And it says Section 38. So that's what you saw last time we were in front of you. You may recall that during that meeting, the question came up, or the concern was raised that, well, this provision would allow the short notice that this provision provides for menial things like a parking ticket or a parking ticket in Santa Monica or a citation from the FAA, minor things. And so when we received that comment, your authority asked that we go back and revisit this section. So we did. And what you see on the right-hand side of the screen is the provision that we have now in Section 38. And it has what we've done is, as you asked, raised the threshold of the types of acts that would qualify for shortened notice. And then off on the left side of the screen, you see under the heading current lease, you see what the lease that's currently operative says about this same shortened notice provision. So what Section 39 does is, if you look at it, the beginning of it, it provides the tenant with 30 days notice. And that's more than the law requires. The law under Code of Civil Procedure Section 1161 requires only 3 days notice for terminations of a lease and the filing of an unlawful detainer action when there's been a breach of a material term of the lease. And so Section 39 currently provides 30 days notice, or requires 30 days notice from either the tenant or the county for termination of the lease. And then it has this exception that you see on the screen that says that in 4 special cases, and it's not just criminal acts, it's criminal acts, a deliberate act of violence, or a failure to comply with the lawful instruction of an airport employee. In those 4 special cases, and it also includes threats and attempts to commit those things. In those 4 special cases, we revert to the standard notice that's allowed by state law under Section 1161 of the Code of Civil Procedure. That's the 3 days notice. So Section 38, again, is a notice provision. It allows for extra notice in case of most breaches, allows for the shortened 3-day notice in a limited set of circumstances. So, but to understand how Section 38 Section 39 would work in practice, it helps to understand that the proceeding by which a lease gets terminated is an unlawful detainer proceeding. That's a court proceeding, and every tenant is entitled to have his case heard in unlawful detainer proceedings if they contest the breach that's alleged by the county. And so what would happen in an unlawful detainer case is that the burden would be on the county to prove that the tenant is guilty of unlawful detainer. And so we would have to prove that to a court or to a jury in some cases. There's another section of the unlawful detainer law that says that a jury trial is required in any case where there's a factual dispute. And so that's the due process that's provided to all tenants if they request it, or if they want it, if they dispute the breach that's alleged by the county. The breaches of the lease that would result in the shortened notice here under Section 39 are going to be violations of law. And in Section 4 of the lease and Section 27 of the lease, you see provisions that require the tenant to comply with all laws. I'm paraphrasing, it's specifically set out in the lease, but essentially comply with laws and regulations, etc. So a violation of law or a violation of a regulation or instruction or order of an airport employee can constitute a breach of the lease. And if that breach is material, meaning it's not trivial, it's significant or substantial, and somehow frustrates the purposes of the lease, then a court can order, assuming the facts underlying the breach are proven, the court can order that the property be returned to the county. And that's in essence how an unlawful detainer case works. So Section 39 does not grant the county any special rights or any special powers or any special authority. All it does is call out the notice requirements, 30 days for most breaches, and then the standard 3-day notice under California law for these 4 special cases.
And that concludes the opening presentation for this discussion, and we're ready to field questions, or if you would like to discuss and then get back with us on questions, however you'd like to move on that.
I personally do have a couple questions before we go to public speakers. I know all of our commissioners probably do as well. Tom, if we can go back to that slide for this item 39. I've talked to both Tom Temple and Kip Turner on this. The question I have is, in the past, coming to our board, we've had a position, in a situation which was a he said, she said kind of thing. And we went into court and there was a lot of money spent. And there's a concern that I have personally when a deliberate act of violence against any person or a failure to comply with the law instruction of any department of airport employee is very lenient. Wouldn't the police be involved in that type of situation so that the pressure to one of our employees making that call that it was that they gave a lawful instruction and the hangar owner or whoever that was didn't follow it? or the employee said that they did some act of violence and the hangar owner said, no, it wasn't me, it was someone else. How do we, this seems very liberal. How do we do it so that there's just cause is proven? I'm not a lawyer. There's other lawyers on this commission, but those are two that are very vague, and I think sparks some further discussion on.
Okay. And well, the acts that constitute a breach of the lease are set forth not in section 39. That's not where those breaches are described. The breaches are described in section 4 of the lease, I believe it is, and section 27, as I mentioned earlier, that discuss the tenant being required to comply with all laws. Again, paraphrasing.
But you're saying that if they do one of these 3 items based on what's in here, you state that it's an immediate termination under those 4 conditions. So I wanted clarification.
Yeah, no, there is no longer a phrase immediate termination in section 39. Immediate termination, I know was in the prior version. You can see there in the middle of the screen, it says terminate this agreement immediately. That was confusing and misleading. There is no such thing as immediate termination, so much as what you have is the amount of notice that must be given. So we tried to make this more legally sort of on point. So we require 30 days notice for most breaches, and then in limited circumstances, 3 days notice.
Right, so
but the acts that could, I'm sorry.
Go ahead, please finish.
Okay,
sorry.
yeah, so the acts, I'm repeating myself, so I admit that, but the acts that constitute breach of the lease are the acts that are listed in sections 4 and 27, among others.
Okay, so what would be a lawful instruction of any department employee that would be someone would fail to do?
Well,
do you have an example?
So that language regarding a lawful instruction of an employee derives originally from the current lease, as you see there on the left of the screen, lawful instruction of airport servants or agents. And I believe, although I was not able to pin this down decisively, but I believe that derives from the Ventura County Ordinance Code, under which the Board of Supervisors has delegated to the Director of Airports sort of plenary power to issue directives, regulations, orders to control operations on the airport. And so what we're talking about here are significant acts by someone that require immediate intervention for purposes of safety or security, either of people or property, and so that the airport can continue to function and remain a relatively safe place. So though it's going to be, I mentioned earlier that a breach that will constitute unlawful detainer must be material or substantial or significant, and the breach must do something to frustrate or that's linked to the lease in some way. It's not a breach of this lease or frankly most leases to get a parking ticket in Santa Monica, for example. It would not be a breach of this lease to commit any minor act. We have individuals who have made comments to the effect that some minor act could constitute a material breach to lease. It has to be significant or substantial to constitute a breach.
Well, and sorry to get in the weeds on this, but what is significant? What is major? So I think we're setting ourselves up to say, well, what I did doesn't fit into an act of violence. I got mad and I did some, I threw a can against the wall or something like that when you were, whatever. I don't know. I want to make sure that we're working with our community. We're a small town airport to me, even though we're big. And this is definitely a partnership that I want to make sure we're clear on this so that we all feel safe on this. I think that it's very vague, those 2 lines, and it's all set up for interpretation, which might not resonate. At least it doesn't with me. So
The problem, I'm sorry, the problem that you're describing is not unique to this lease. It exists in every lease. And so just one example is Code of Civil Procedure Section 1161 has a provision in, I think it's subparagraph 4, that says that any lease can be terminated on 3 days notice for maintenance of a nuisance on the property or use of the property for unlawful purposes. Now, what constitutes a nuisance, if you ever become familiar with nuisance law, what constitutes a nuisance is wide open to interpretation. But that's what the statute says. An unlawful purpose, what constitutes an unlawful purpose or use of the property for unlawful purpose? It could be any number of things and is open to interpretation. But the fact that something in a lease is open to interpretation does not invalidate the lease or make it impossible to put it into effect. Every lease is subject to this same problem. And that's why there is a right for the tenant to have his or her case heard and in an unlawful detainer proceeding if there's a dispute about the factual basis for the breach. Now, because this is a court proceeding that the county would have to prove by a preponderance of the evidence that a breach has occurred, that naturally means that the county cannot proceed on a case for which there is doubt or an inability to prove the breach. So you mentioned Supervisor Long, a he said, she said situation. Well, if the evidence does not show beyond a preponderance of the evidence that a breach occurred, a court or a jury would certainly not find that a breach did occur. So that's the way it works.
I got you. I think those two are vague and doesn't give the our staff enough time to make sure that that was the case. So I would think that those would be in the 30 days, but I'm going to let other commissioners ask any questions. Anyone else have any questions on the hangar? Susan, Councilmember Santangelo? Go ahead.
Yeah. So if I understand, you stated that this section is not about the breach, it's about the notice. Is that correct?
Yes, that's correct.
Okay, so can we go back to the slide that we were just on that shows the, yeah. So none of these things constitute a breach. They are a reason to give only a 3-day notice. Is that correct?
Correct.
So there would also have to be a breach.
Oh, absolutely. Yes, you can't terminate a 20-year lease without a breach.
Okay, so if somebody beats up an airport employee, is that a breach?
It could constitute a breach, and whether or not.
What? Where in the contract do I find that?
Well, you would find that in the, let's look at section 27. Under section 27, the tenant agrees to abide by all applicable statutes, ordinances, orders, laws, rules, regulations, etc.
So it's just really confusing to separate out the notice from the breach. And I agree with Supervisor Long that that these things are vague. Who decides if it's a felony or a misdemeanor?
A judge or a jury.
But you have to serve that 3-day notice first before that's decided.
Yes. So if for example, you had a case that was readily provable and the evidence was very strong, and you had all that evidence within 3 days or immediately, then you could then provide the tenant with 3 days notice. Now, it could take a week, it could take 2 weeks, it could take 3 weeks for the county to be able to gather the evidence necessary to allege something like that. And if the case took longer than that, then we would simply provide the 30 days notice here and move forward. But if there's a clear case of a violation that for which we could prove that the notice required is only 3 days, we can go forward with that. Now, I mentioned unlawful detainer before, and we would have to prove the breach. I failed to mention earlier, and maybe this is confusing, we would also be required to prove that the notice given was sufficient. Notice is a very big part of unlawful detainer, and if you don't give the correct notice, the court will throw your case out. So if we were to give too short a notice, meaning a court later concluded that, well, it didn't meet the short notice requirements and therefore we were required to give 30 days, we'd lose the unlawful detainer case.
Isn't a felony or misdemeanor a crime, and isn't that decided in a criminal proceeding?
Well, the lease says that it can be a breach if it's a violation of law. All we would have to prove is that the acts in question did constitute a violation of a statute.
But if it's a criminal proceeding, a felony or misdemeanor, isn't that proven in a criminal proceeding?
Oh, certainly. And if there is a crime committed on the airport and the authorities investigate and it goes to the DA's office would have to decide whether it has enough evidence to prove a criminal case and then move forward that way. But
this notice is based on giving a 3-day notice for a description of a felony or described as a misdemeanor. How is that known at that time if it hasn't been adjudicated?
Well, that, again, the question that you're raising has to do with all breaches of a lease. So how do you prove
Wait,
that the
I'm
acts in
talking about the
question?
notice, not the breach.
Well, you have to prove a breach. You have to prove that the breach violated a statute. And so in the case of any breach where we would allege a violation of a statute, or let's use the Code of Civil Procedure section 1161 sub 4, we have to prove that the premises were used for an unlawful purpose. We have to prove unlawfulness. We have to prove that there was a law that prohibited what was done and that what was done violated that law. So that's the case of in the case of all breaches. And I can tell you, based on my experience, in most circumstances, you would not be able to prove by a preponderance of the evidence, or you would not have a sufficient case within 3 days to prove the case. But in some cases, you do have those facts. And so this lease provides us the flexibility in these 4 special cases, in the case of a breach, all of which is extremely rare. And that's the procedure that would be given. So this lease does nothing more than give the county the standard 3-day notice for breaches of the lease in these 4 special cases.
Well, I think that an unlawful detainer proceeding has it's much different than a criminal proceeding. I think the burden of proof is much different. But I also noticed that in your answer to me, I'm asking about the notice and you're talking about the breach. And I think that actually is a perfect example of why this is confusing. So that's all I have.
Thank you very much. Bill Thomas, I see your hand is raised.
Yes, ma'am. I guess that my problem with this particular section is the fact that there isn't, you either go to trial or you give up and lose your lease, because there doesn't seem to be anything in the middle. And if you're a rich person with deep pockets, you can probably go to trial with the county, and as we've seen, probably have a 50-50 chance of winning. But if you don't have the money to afford going to trial, there seems to be certainly a way that the airport director could review, which I'm sure he would, but then if it's something relatively simple and not a criminal type of breach, that there ought to be a more simplistic and a less expensive way. And by the way, if it goes to trial, the airport has to pay the county to represent it too. So both sides are losing money on this, the enterprise fund and the individual. And it just seems to me that there's for the very few times that this would ever be put into effect, there ought to be a county recognized means of something other than having to go to court to do the full enchilada. Thanks.
Thank you, Mr. Thomas. Supervisor Ramirez, I'm sorry, your hand in the participants was up and I didn't have that pulled up.
Oh, that's fine. That's fine. I'm looking forward to hearing, we're going to have significant public comment. Is that correct? I apologize for coming. I had to be here a few minutes late. So we're going to hear from people, correct?
Yes. How many speakers do we have? I have no information on this.
Okay. All right. Well,
Hi, this is David. We're gathering some momentum on that. 3 so far. I'm sure we'll see by.
okay. Well, I am looking forward to what, and I think all of us have been hearing from people interested in this. I've been hearing lots of, and not just hearing, but getting documents, et cetera. And it's a little difficult to process that all the afternoon of, especially when I think for me, I had a very heavy day. I couldn't really focus on the things, unfortunately, that were sent to me that were pages and pages. I will say that I'm an attorney and I spent a career representing tenants who are being evicted. They were residential tenants, and it is a very quick process. Usually, even in the case of a nuisance, there's an ability to cure, and I don't know why that isn't part of this, you know, that there should be an ability to cure. Obviously, if somebody has a gun and is hurting people or is threatening it, that's a whole different thing. Please call the police, call the local law enforcement. But I think I'm very concerned that this in particular has raised so much concern that I really do want to hear from people, but when you go to trial in unlawful detainers, even in commercial or non-residential, it's an extremely quick process. Even if you have my experience, even if you have a terrific case, it's dealt with in a summary fashion and people could lose very important rights if we're not very careful here of making sure that people's quote unquote due process rights. So I have the sense that the language is a bit vague, not even the language, just but how it would be enforced. And obviously there's some concern on our lessees that there's some potential for arbitrary conduct. And I'd like to see that lessened, that concern, maybe by figuring out a little bit more specific language, because I've heard now 2 commissioners, Chair Long and Commissioner Santangelo, say the word, I think I heard you say something about it's confusing, it's vague. And these are 2 smart ladies too. So, and Mr. Thomas as well. Not a smart lady, but a smart fellow. Thank you. I'm concerned.
Thank you. And Carmen, Supervisor Ramirez, that was a good point. Did the 2, I think there were 2 letters. One I received from Kip this afternoon on item number 37, and then also something from Scott Bear. Will those be to the record as well? I think that's important for people to know, and usually that's available for the public. So is that on our website so that people will have that as well?
The only item we're aware of this afternoon, you were sent a frequently asked question supplement to section 39 because of the continuing speculation about section 39. We're happy to put that on anybody's website, including ours. Yeah.
Okay, I think that's important for people to receive. And then there was a rebuttal that was sent to all the authority members from Keoka. I said it wrong. So I want to make sure that you are all aware of that too.
We're not aware of that. We've not been privy to that.
Okay, we'll get it sent. There's a lot going on, and I agree with Supervisor Ramirez that it's very hard for us to digest all the information when it's come to us late in the day. So does any other commissioners have any comments? Sean, Commissioner Mulchay, Vice Chair Mulchay, please.
Yep. Thank you. I have one question, and it follows along Mr. Thomas's line of questioning in regards to a process or the lack of any kind of mediation clause that's included in this, and why not have a mediation clause? It's very common, or I find it to be very common in most contracts. And I've heard the county argue that they want the process to be either speedy and efficient, and as not as costly as or less costly. But along the lines of what Mr. Thomas had brought up, my concern is, wouldn't mediation be a lot cheaper than the other two alternatives, which is the tenant, if they feel like they're wrong, if they don't have the resources to mount any kind of defense, then they simply just don't do anything and they get steamrolled. And the other one is that they immediately launch into litigation with the county, and then obviously the clock starts ticking and the bills start rising rather rapidly. And I see litigation as being a very drawn out, long, and expensive process, as opposed to some sort of mediation. Is there a specific reason why the county didn't pursue including a mediation clause in this?
Yeah, I'm sorry, is that me speaking or Tom? I'll go ahead and start off.
It's directed towards either one of you, whoever's best equipped to answer.
Yeah. Basically, in short, mediation would, it's actually the opposite. Mediation would add cost to both parties, because the tenant would still have the ability, if they went through mediation and they didn't like the outcome, they would still have the ability to go through the UD process. So for, at least for the county, it would be a lot more cost, because we would have the cost of the mediation, and it would delay the whole process, where as has already been noted by one of the commissioners here tonight, the UD process is a quick process. So when you add mediation to that, you add delay of time to that, you add cost to that, and then it still results back ultimately if a party's not happy with the UD process. So, and usually mediation is more for your large corporate commercial type agreements, not for something this small, for a small private hangar owner agreement. So I've not ever seen mediation involved in any of the small private hangar owner agreements that I've seen over the years, but I have seen it for large corporations or large companies that have millions and millions invested and hundreds of employees or something like that. It's a different scenario.
All right, thanks.
Okay, any other commissioners? Either raise your hand or speak. I don't see any raised hand in the panelist. With that, I do know that we have some speakers. Do we want to start with the Camarillo Oxnard Hangars Owners and Tenants Association? I understand there's 5 people that want to speak. We could let them start first. I mean, might as well.
Yeah, right along, we had 2 gentlemen who contacted us earlier today and have slides. So we would start with Scott Bear. And,
okay. Okay. Scott, are you, with your slide, are you the first speaker, or is there, I've given each person who speaks today 3 minutes. Is there is someone else that is speaking before you? And if you could let him in so he can speak. Because I believe there's a Jerry DeSimone, a Leslie McAdam, Barry Groveman, Mark Carnick, and Scott Bear.
That would be our preferred order, Mr. Vice.
Okay. So if you could let those 5 in, I'd appreciate it.
And in that order, because comments build on each preceding speaker. So if it's possible to go in that order, that would be great.
Okay, but you get 3 minutes each speaker. So that would be just so that the first one's Jerry. I'm looking to see if he's in there. Bring him in. And then Leslie McAdam. Bring him in. Barry Groveman. Bring him in. Mark Carnick.
Chair Long, this is Dave. staff indicates that it's easier to manage the queue if we let them in one at a time, and the system
Okay.
is able to keep them sorted.
Well, then,
according.
okay, then just bring in Jerry.
Chair Lowe, we'll start with
You can
Scott.
take my slide down because Jared won't be using it.
There you go. So you can kick Scott out and and bring Jerry in. No offense, Scott.
No offense taken, Supervisor.
Each system, each board meeting has a different way of doing it. So
Who's starting now?
so Jerry, when you get let in, you have 3 minutes. Okay, come on down, Jerry. There he is. All right, your mic is on, but there's no video. Okay, there you are.
Good evening. I had actually asked to have something posted, and I don't mind that being instead of my face, as I'm not that good looking to start with. But my comments basically are regarding the 4 denominated types of activities that have been referenced so eloquently by the supervisors and councilwoman. To start with, it references accusations. While Mr. Temple does talk about a summary proceeding and unlawful detainer has a certain burden of proof, which basically is much less than the beyond the reasonable doubt of a criminal accusation. So simply put, if somebody were to accuse myself as a hangar owner of punching them in the mouth at Camarillo Airport after dark, and in fact, I could prove that I was somewhere outside the state of California, on the accusation alone, I would only be entitled to 3 days notice and a preponderance of the evidence. That violates the rights that have been bestowed upon us by the Constitution. I am the lawyer who actually went to trial against the county involving the anti-risk matter. For those of you who know me, for those of you who don't, let me introduce myself. I think we'd all like to think that the county Department of Airports would never retaliate against anyone and make a false accusation. However, a Ventura County juror found that that was not true. They found that there was retaliation. Now, I understand, and Mr. Temple might talk about this, that in fact, the judge granted a new trial in that case, but I asked Scott to please send the judge's actual ruling on that. And it was not overturning the issue of retaliation. It was saying the judge erred in not giving an instruction that, well, even though the county retaliated, perhaps they could have let him go for another reason. So those are issues that need to be addressed. My big concern here is we're essentially allowing the Department of Airports to be the accuser, the jury, and the undertaker in this case by giving a 3-day summary proceeding with a much lesser burden. And I respectfully disagree on the issue of an alternative dispute resolution with Mr. Turner. There are a number of people who provide community ADR. That can be done through Pepperdine University, who has the top school in the country in ADR. They'll have students do that. And saying that the tenant would just move on, it might be the county who changed their mind in an alternative dispute resolution or mediation. Thank you very much for your time this evening.
Thank you very much for your comments. Okay, next is Leslie McAdam. Hey, I see Leslie. Hello. Go ahead.
Good evening. My name is Leslie McAdam, and I am an attorney at Ferguson Case or Patterson, which is the largest law firm in the Tri-County area. I practice in the area of unlawful detainers, and I've been doing it for about 20 years. I am not representing Cahota, nor is my firm. I'm not any part of the negotiations of the lease. But Cahota contacted me to review paragraph 39 from my perspective as a practitioner as to whether or not it's commercially reasonable. It's not. I can see the interest of both sides. The county wants to protect health, safety, property. It's entirely legitimate. But the tenants have some very valid concerns. I see two main issues. The first is that it's conceivable a tenant could be accused of a misdemeanor, lose their 20-year lease in a 10-minute trial, and only to get acquitted 6 months later. And that's just basic unfairness. This isn't the same kind of thing as an at-will employment situation. We're talking about property rights. What concerns me also is paragraph D, which is the failure to comply with a lawful instruction of the department. Now, I get it. The county wants the tenants to comply with their orders, and that's perfectly legitimate. But paragraph D makes what should be a curable default non-curable. The language does not say a willful failure of a tenant to comply. It doesn't say a material lawful instruction, and words matter in a lease. If I had more time, I'd tell you I'm going to trial on Monday. In unlawful detainer court, we are arguing over whether an email constitutes a writing in a lease, because it's an old lease and it doesn't define a writing as an email. So it's better to solve these things early before you get the lawyers involved. I urge you to work with CAHOTA because I think this lease language can be fixed. And I would be happy to answer any questions anybody has on how unlawful detainers work, as I don't have a dog in this fight. I'm just here sort of as an expert on the topic. Thank you.
Thank you, Leslie. Okay, next would be Barry Grossman.
He doesn't have his hand raised any longer. Do you still have a comment?
I believe he's on the list.
Okay. His hand is no longer raised, so.
Barry, if you're going to speak, would you raise your hand? That's in the participant area. You go to the bottom right and you click the raise hand. If you're going to be speaking, please. Not everyone's Zoom literate. Does he have it now? There we go. Great.
Okay,
Hi.
Can you hear me now?
Yes, thank you. Go ahead.
Excuse me 1 second while I adjust this. Okay,
All right.
Can you all hear me now and see me?
Yes, go right ahead.
For some reason, I couldn't see any of the controls.
It's okay. Your time is starting.
Okay.
Go for it.
Thank you very much, members of the board and Mr. Turner and Mr. Temple. I'm here tonight. Well, first of all, my name is Barry Grossman. I'm a former, just by way of background for hopefully a little enhanced credibility, I'm a former assistant Los Angeles city attorney in LA, and I'm a former special assistant district attorney in LA. I was also the mayor of Calabasas, and I've written numerous statutes and ordinances, both statewide and locally, including California's Prop 65. And by way of reference, my partner is Mike Bradbury, the former district attorney of Ventura County. And I've discussed paragraph 39 with him, and he concurs in most of what I would like to say. You're all very correct in being confused. I want to at least say that I don't intend to in any way be confrontational. I assume that the director and county council are well-intentioned, but they may not have considered the consequences of what this paragraph is doing. And I think everybody is not clear on what it is. This is not about notice or timing. It's about due process. And I think what I'm seeing is that for good reasons, the airport board, the airport wants to deal with what they think might be serious issues, but they know that if there are crimes that will lead to a revocation of the lease, that's going to take a long time because you have to wait for the criminal courts to give everybody their due process rights. So in order to short circuit that, they say that if it's a serious crime or threat of a serious crime, there's a shortened time period to get into UD court for an unlawful detainer, at which point they have to then prosecute the case in unlawful detainer court. And they say the burden would be preponderance of the evidence, but that's not true, because if you're going to prove that they've committed a crime, it's going to be beyond a reasonable doubt. That's where I think this paragraph is off base with all the right intent. Just to give you a few examples, I don't believe that they've considered talking to the stakeholders. Have they talked to the sheriff? Who's going to do the investigative work to bring this case in court? Has anybody talked to the presiding judge in Superior Court to make sure they will allow a UD judge to do it? Does the UD judge have experience? Who's going to prosecute it? County counsel? Do they have any prosecution experience? Are they trained? Can they use the discretion? What's the impact of all this to the district attorney's case? And what if you're acquitted by the DA and found guilty by this process? Is there immunity for the county, for somebody that gets into trouble over such a, I know I'm running out of time.
Yes.
It's difficult. Yes.
Well, sorry, you're out of time. I appreciate it, but perhaps we can ask questions later if anyone needs it. Thank you. The next person is Mark Karnick. Mark Karnick. I'm resetting my timer. I don't know if you guys have a timer over there, so I'm trying to be good.
Hi, can you hear me?
Yes, go ahead,
Great.
Mark.
Thank you very much. All right, thank you very much for the opportunity to speak to you tonight. As you know, the Aviation Advisory Commission voted to send the lease back for further negotiations. This is now the third time that the lease has been rejected between the Advisory Commission and the Airport Authority. And if you're wondering why it's been repeatedly rejected, it's because what we're all experiencing right now, which is that when reasonable people read this lease, it doesn't sit right with them. There's these vague provisions, there's language like threatened and attempted that don't really kind of match, American values and jurisprudence. And finally, the heavy-handedness of the language really, sparks a suspicion of government overreach. And frankly, none of the explanations of the county council have dissuaded any of that unease. So what this comes down to really is a matter of trust. And as many people have commented, trust right now is an all-time low for lots of reasons, going all the way back to the ad hoc committee. We were hopeful that a new director of airports would restore some of that lost trust, but the best you can say about that is that there's been mixed messages. We're told that hangar owners are welcome, but then we hear that, we're called a cancer on the airport. So it's not very reassuring. And finally, of course, there's Andy Risk, which was already explained, but nonetheless, a jury did find that the Department of Airports retaliated against a hangar owner. So what can be done? And specifically, what can be done tonight, right now, to restore trust and to resolve the lease issue? And I suggest that what needs to be done is for the Airport Authority to send this lease back to the county, back to the Department of Airports, and tell them not to come back until they have a lease that can be supported by all of the stakeholders. And that means talking to Cohoda, talking to the other hangar owners, which is something that the Department of Airports has not been willing to do. They haven't talked to Cohoda since 2019. And Cohoda, for its part, has demonstrated good faith over and over. We're not the enemy here. We want the airports to be successful. We don't want dangerous people in the airport. And we want the Department of Airports to have all the authority they need to run a first-class airport operation. We are just as invested in the success of the airport as the county is themselves. All we need now is for the county and the Department of Airports to be given a clear mandate to negotiate a fair lease that can be supported by all the stakeholders, and that's what we're asking for tonight. So thank you very much for your time, and I will yield back the remainder of my time.
Thank you, and good, you're within your 3 minutes. Scott Bear. I couldn't see the timer because I need a bigger screen. I had my participant list on there. Okay, so Scott, we have your slide up. So you have 3 minutes when you unmute yourself.
I can't see a timer either. Let me put my own up here. See if I can figure out a way to do that. I can't.
I think it'll show when we start.
Okay, I appreciate that.
Okay, so ready, go.
Good evening, all. The lease before you has already been rejected by the Aviation Advisory Commission. Why is the Department of Airports ignoring the voices of the community by pushing this rejected lease forward? Slide. From a young age, Americans are taught two things about this country's system of justice. You have the right to be treated fairly by your government when accused of a crime, and you are innocent until proven guilty. Make no mistake, our county's airports should be crime-free, but in America, our constitutional rights cannot be trampled to achieve that goal. Slide. The unlawful detainer process does not provide criminal due process guaranteed in the Constitution. In the UD process, there is no investigation by police or sheriffs. Does an airport staffer determine whether there's been a crime? That's just not right. There's no time for a defendant to prepare a defense. The proceeding does not adhere to the constitutional requirement of proof beyond a reasonable doubt. And they do not require a criminal jury to reach a unanimous verdict of guilty. The unlawful detainer process has nothing to do with criminal due process. Slide. You've heard discussion tonight about burden of proof. If the county is going to accuse someone of committing a crime, they must prove that beyond a reasonable doubt and convince 12 jurors unanimously to have an abiding conviction that the criminal charge is true. That's the American way. But the Department of Airports wants to terminate leases for criminal conduct without following criminal constitutional law. That is not the American way. Slide. By simply adding language to paragraph 39, requiring a conviction in criminal court, due process is satisfied. The red underlined language in this proposed revision is an example of all it would take. Slide.
1 minute.
3 experts have said tonight that the lease is unacceptable. Leslie McAdam, a 20-year practitioner and unlawful detainer, said the lease fails to provide sufficient legal notice and has the potential for abuse by the Department of Airports. Jerry DeSimone, who has litigated against the county on airport tenant issues, said the Department of Airports cannot be trusted with the unfettered power it is seeking. Barry Groveman, a former deputy district attorney, deputy city attorney, and mayor of Calabasas, said that the lease violates due process and exposes the county to liability. The bottom line is this: do not be fooled by claims that the draft lease protects tenants' constitutional rights. It does not. Please remember the American way and do not approve this lease with its un-American power grab. Like the Advisory Commission, please tell the Department of Airports to work with COHOTA and preserve tenants' constitutional rights. Slide. Thank you for your consideration. I'd be happy to answer any questions.
Thank you, Scott. Appreciate it, and all your members. Okay, next we have is 4 more raised hands. First one we have, I believe, on there is Joe Leckman.
Hi, can you hear me?
I can hear you.
Great. Well,
go right ahead.
Good evening. One of the most important things our government should do is treat all citizens not only fairly, but also equally. This lease discriminates against private hangar owners in very material ways, and in violation of the FAA sponsor assurances that forbid unjust discrimination among airport users. The lease imposes upon hangar owners new access and use restrictions not imposed on any other airport users. The new lease forbids a hangar owner from driving any vehicle on the airport unless that vehicle is registered to the hangar owner and given an access decal by the airport administration. Rental cars, loaner cars, and passenger vehicles cannot be driven by a hangar owner, even if they're registered and properly insured. I can't even drive my 2 young granddaughters to my hangar for a flight, as my car lacks required child safety seats, and I don't own my daughter's car, which does. It even forbids parking a passenger car in a hangar when that passenger is using the plane for travel, even though that use is specifically permitted by FAA hangar use policy, and long-term parking for passenger cars is not available elsewhere. No other airport users, such as county hangar tenants or the FBOs, have such restrictions placed on them. Driving rules are already set forth in the Ventura County ordinances that uniformly apply to all airport users, and violators of those ordinances will be tried in a court of law and punished if found guilty. Any changes to the driving rules need to be done by amending the Ventura County ordinances that will apply to all airport users, rather than inserting unique restrictions in private hangar leases solely applicable to private hangar owners.
1 minute.
Not to beat a dead horse, but as to paragraph 39, it doesn't require a criminal conviction. So what if a tenant is evicted because the airport staff thought that the tenant attempted to commit a felony, and later the tenant is found innocent in criminal court? Now what? His hangar's gone, and who knows where his airplane went? Sounds like wrongful eviction and a terrible injustice to an innocent citizen, all at the hands of the county. Is this really the way Ventura County wants to treat hangar owners who have faithfully paid taxes and invested millions of dollars to make this airport the great airport that it is? I think not. Thank you.
Thank you, Joe. Appreciate the emails as well. I know we've all been getting them. The next one would be Mark Schroeder. Go ahead, Mark.
James Schroeder.
Or sorry, James Schroeder. I was looking at the next one as Mark. Sorry. Go ahead, James.
Hang on 1 second, because I've lost my script here. So I apologize while I get it up again. Okay, James Schroeder, hangar owner, Oxnard Airport.
Go ahead.
Regarding section 39. In the last meeting, the county argued that they did not want to wait for legal processes to complete to determine guilt or innocent before triggering the breach. So if somebody is accused of a breach, is that person allowed access to their hangar and aircraft? I think not. If not allowed access, does that then mean the hangar and aircraft owner must wait until they are exonerated before gaining access to the hangar and aircraft? If so, that could take a long time. So in my opinion, the county is taking property unlawfully. Thank you.
Thank you very much. Okay, James Schroeder. Next is Mark Sullivan.
Mr. Sullivan had a slide as well. We're pulling that up.
Okay, are you ready?
He's still on mute.
Go ahead, Mark. Maybe it was me on mute. Go ahead.
There we go. There we go. So my name is Mark Sullivan. Been an attorney for, I hate to admit this, so long, 49 years, and a renter at the Ventura and both Ventura airports, Camarillo and Oxnard, since 1984. My main concern with this is that my dealings with the UD echo exactly what Supervisor Ramirez said. UDs, by definition, are summary proceedings. And what's being forgotten here is that this hangar lease is a commercial lease. As such, a court is going to strictly construe it right by its terms. Now, Director Turner says that in the rewriting process, they try to remove minor violations to have much greater clarity and to reserve immediate termination for criminal violations only. The problem with it is that when Mr. Temple talked about criminal violations, having a potentially a material impact on the airport, I have no problem with that concept, but that's not what the lease says. If you look at it, you'll see in 27 basically says you will violate no law. Well, the Ventura County ordinances combined with the California Penal Code and California Vehicle Code, which together are about 9,000 pages of 6-point type, there are literally thousands of innocuous acts that are either infractions or misdemeanors. The Ventura County Code says that every violation of the code, and it's in section 13-1, every violation is discretionarily charged as a misdemeanor. That means that basically any small violation of the airport code could result in somebody forfeiting a $70,000 or $100,000 hangar. And to the point that, for example, that if somebody comes into your hangar and they're smoking and you don't get them to stop smoking, arguably under the ordinance, you've committed a misdemeanor. You haven't been active enough, anti-smoking policeman, or if they have their dog off leash. These are very minor things. I suggest that the cure to this is, as Leslie McAdam pointed out, it's a drafting problem that paragraph 39, if in fact we're concerned about conduct that arguably would have a material impact on the safety of the airport, it should say that. So that, sure, you have to abide by all law, but if you engage in a violation of law and the violation of the law, has a clear and present impact on the health and safety of the airport, then and only then could you have an immediate termination. And I would submit it'd be easy enough to add also the clarifier of clear and convincing evidence, which is usually what's required for the equivalent of getting an immediate court order. Thank you very much.
Chair Long, you may be on mute.
Thank you. So I was having a great conversation with you. If there's any speakers, the next one is Lynn Milhart is the last speaker. I do not see anyone else's hands risen, but if you do, go to the participants and hit the raised hand. So when we bring Lynn in, he has 3 minutes. Hi, Lynn. Now you're on mute. You're on mute, Lynn. Can you unmute yourself?
There we go.
Thanks. We're playing this game today. Sorry.
Thank you. First of all, thank you for the opportunity to address you. For the benefit of those that don't know me, I've been a professional pilot for 50 years. I got my first flight by being solo was out of Oxnard in 1970, and I've been flying in and out of Oxnard and Camarillo privately and professionally, for that matter. I have a number of issues. Most of them the people have addressed tonight. I think the big takeaway that I'd like to leave everybody is that it is not the responsibility of the airport authority and the airport leadership to become the moral police officers for behavior that is covered by the courts. if in fact people are concerned that these 4 items have violations, they are clearly the purview of the criminal court system, and that's where they belong. And to me, this is all about a lease. You don't own my hangar, you don't own my airplane. I have to use an airport that is certified by the FAA to fly, and it happens to be in Ventura County. So the privilege of renting a piece of property means I put everything at risk for a moral decision that is being made by people that aren't in the moral judgment business. I find that offensive. I would suggest that, for example, if you take item D, the failure to comply with a lawful instruction of any county Department of Airport employee or agent. Every employee, do they have IDs? Is it a legal ID? How do I know if somebody is an agent? I don't know that. What if somebody from the county comes up to me and says, you can't do X, and I go out and try to figure out to solve it, and somebody else comes later and says, no, you can do that. Where is the record that either one of them are correct, yet I put myself at risk? I think there's so many things that are in this document that lead to a misinterpretation that I would encourage the county, seriously, the county, because it's the county that says, even said tonight, Kip said tonight, I don't see why we need to meet because we're not making any changes. We've given all we can give. That is not the correct answer. The correct answer is, let's make this agreement functional for everybody. And I think the suggestions you've heard tonight are in fact good suggestions. Let's sit down and determine, are we going to be moral cops and police everything to the nth degree? Are we going to treat our hangar owners at the same level we treat our FBO owners, give them the same due respect? And are we going to not shorten everybody's constitutional rights because somebody has a suspicion? I think you're going in the wrong direction. And I encourage this board to direct county staff to solve this problem and not delay.
Thank you, Lynn. You are the last speaker. Can I ask you a question? Joe, what was his name? Joe spoke earlier about driving a vehicle on the airport. I myself don't always drive my own car, especially if I have kids or whatever. Have you had experience with driving with a sticker and you can only use that one car? And what if you have your wife that's in another car? Have we had problems before to drive 2 cars and park them in?
So my suggestion, I think it's a great question. I have 5 vehicles, and each vehicle I use over time. If I have to move something in and out of the airport, I bring my pickup. If I don't, and I'm going to store it, I bring my small car. If my wife wants to go with me, I bring my wife's car. My suggestion is, forget about the stickers. Let's do the same kind of window clip that we do for handicap parking and other events, just like everybody. You can go to the Dodger Stadium and you don't have to have a sticker. You get a pass that you put in the window. You put passes in the window when you put the money in the ticket meter to show that you've paid. There are ways to solve the problems that we're creating for ourselves and not bog ourselves down into a lot of bureaucracy.
Okay, thank you. I just had to ask that one question. Thank you so much. Oh, crud. There is a Norman Hall. If you want, I think, and that'll be our last speaker, Norman Hall.
And Miss Long, this is on after Mr. Hall speaks, you have 1 written comment that was received.
Oh, great. Thank you.
Say something. Can you hear me?
Yes, go right ahead.
All right. Thank you very much for entertaining my thoughts tonight. I'll be very brief. I have one question for the commission regarding the county lease agreement. After hearing the county council's comments and the comments made by the commissioners and the speaker's comments, would you want to sign this lease agreement as it is currently written? That's my comment. Thank you.
Thank you very much, Norman. That is it for the speakers, and we have one. If Anna, if you could read that in, or is there someone else that's going to read that one?
I will read it in. Thank you.
Thanks.
The comment is from John Barut. Dear Airport Authority, it is outrageous that the Director of Airports is now asking you for authority to terminate the month-to-month private hangar ground leases and therefore evict hundreds of law-abiding hangar owners who have supported our public airports for decades. All while a state of emergency has been declared by Governor Newsom due to COVID-19 worldwide pandemic. This pandemic has killed more than 50,000 people in California and millions more across the globe. It has forced most businesses to close and most people to stay at home for over a year. Public gatherings are restricted. These law-abiding hangar owners cannot even meet as a group to discuss a legitimate new lease that will affect hundreds of people with millions at stake. All while traditional public hearings required by the Brown Act are forbidden and temporarily replaced with Zoom or telephones by the governor's unprecedented executive order. What is so essential about updating a month-to-month lease that has been working for decades that can't wait until the COVID-19 pandemic subsides and normal public assembly can resume? Absolutely nothing. This is nothing more than a once-in-a-lifetime opportunity for the Director of Airports to cram through a horribly flawed and illegal new lease during a state of emergency that is suppressing the enormous public opposition he knows will be generated if and when normal life resumes and Brown Act requirements are reinstated. Just say no to this outrageous and wrongful request. John Barut. And Mr. Joe Leckman spoke earlier today, but for the record, he submitted a letter that will be attached to the minutes. Thank you.
Thank you very much, Anna. Okay, so those are the speakers for this item. Is Kip and Temple, I see your videos are off, but if we have questions, you'll be ready to go. Commissioners, I'd like to open it up to you all first for questions. Does anyone have any questions on this? Yes, Carmen.
Yeah.
Supervisor Ramirez, please.
I just think that I recognize there's been a lot of effort put into this by our director and our county council member, but I see the difficulty. I will have difficulty just going ahead and approving this. I think I really would like us to get a good agreement that may not be what everybody wants, but I think we can. I couldn't vote for this now because I do think there's some confusion. I think it needs to be clear what people's due process rights are, the hangar owners. And I think that the contract as written, this particular clause leaves something to be desired. So I'd like to ask our staff to go back and work with some of the suggestions that have been done. And even I know Leslie McAdam, I think she's really expert in this, and I'd like to see if we could get her advice on some of the things she said about the contract and how to proceed. That would be my request.
Thank you, Supervisor Ramirez. We have Bill Thomas.
Yes, thank you, Madam Chair. The two items that I want to talk about, but first I want to say for the rest of the group, Kip Turner, when he got here, had a really, really ugly hangar lease scenario handed to him. And there were people who are really giving Kip and his staff a hard time over the current status of the hangar lease. I'm not happy with a couple of little pieces of it, but probably 95% of it is very spectacular. He has gone way past what I thought an airport director would do. So before we get too hard on the overall package, I think we're talking about little tiny pieces that we can fix. And I think that, Kip, you really did a great job getting together and listening to what people had to say and taking action on it. Now, I said that part, but the two pieces I have a little problem with is One of them is that section with the decals. I came from 20 plus years in the Navy with a decal on my car. And right after I got out of the Navy, the Department of Defense eliminated decals from the requirement to take your vehicle on base, because what they wanted was physical, individual responsibility, not turning the responsibility over to a car to behave itself. They wanted the driver to behave themselves. And so you can go on any base now in the country with the right ID card and nothing on, it can be a rental car, it can be whatever you're driving. Because the reality is, if you're driving in California and if you don't have insurance and you don't have a driver's license, then you're liable for a criminal arrest. So yeah, I think that I would like to see the thing on the decals. Even if we go with the decals later, we pull that out of the hanger lease and we take care of that through another meeting. And but then the other part is I agree with quite a few of the speakers on needing to just spruce up that legalese piece of paragraph 39. And so I really think that Supervisor Ramirez got the right spin on that one. Thanks.
Thank you very much, Bill. Commissioner Thomas, thank you. Next is Councilmember Milche, or Vice Chair. So many titles we have. I respect all of you, just so you
Keep them all
know.
straight. I'll try to be brief. I do, following Mr. Thomas's comments, Kip, I do applaud you and I applaud your staff, because you guys have gotten this ball down the field a lot further in a much shorter period of time than your predecessors. So I think this has come a long way, and it's just that we're down to little items that require a little bit of cleanup. I've heard a lot of reasonable and very smart people speak this evening already, and they're all kind of saying the same thing. They all seem to be on the same page. And I do tend to agree with them. The language, particularly the language in 39, it is broad. I think it is somewhat open to abuse. It does need to be tightened up. And I think it does unnecessarily open the county to either liability or potential litigation because of the language. I would like to see that tightened up. I would like to see the county work with CAHODA and or representatives. I would suggest similarly what the Aviation Commission had suggested, that a few representatives from County Airport meet with some representatives from CAHODA and try to hammer out some of the just the finer language details we can and come to a reasonable solution. That's pretty much all I got. I tend to agree with most of what everyone has already said. And I think we're just 95% of the way there, and we have this little last leg to get over. Thanks.
Thank you, Commissioner Milche. Commissioner Santangelo.
Thank you. I too, I really want to commend Kip, Mr. Turner. This was going on for a long time. You came into a mess, and I think you've really come far. I always try to assume positive intent from people, and my concerns about Section 39 aren't so much that I think, I don't have personal experience of, any wrongdoing or anything like that. So I don't want any of the airport staff to take it personally, but you have to think about what happens if you're not there. This lease persists. So that being said, I also think that the intent of what you're trying to do is not disputed by any of the pilots or hangar owners or tenants. I think they want a safe airport, a pleasant airport. But I think the language is troublesome, and I think there have been some really, really sharp people that have made suggestions and that are willing to sit down and hammer this out. I think you're really close, but I don't think it should just be pushed through because we're so close to the end. I think we should get it right. So I wouldn't be able to approve this as it is.
Thank you very much, Commissioner Santangelo. Yes, Bert Perillo.
Thank you, Chair. It's very good to hear all the comments, tremendous amount of comments. I will go back to the members of the board that were not here some time ago, and I'm not that old, long of tooth that I've been on the board that long, but I do remember when this first came up. This was a hot button issue, and I can remember the night that Supervisor Long and I were in the audience, and there were tremendous amounts of deputy sheriffs, and the place was packed. This has come a long way, but I need to say this. I am a councilman from the city of Oxnard, and I see what happens when people remember things from the past and they want to blame the people that are there currently trying to fix it. Mr. Turner came into something. This was not his baby. This is before Turner. And there are a lot of people that are looking at this as he's the bad guy. And ladies and gentlemen, I don't care where you come from, you work for somebody. Mr. Turner is an employee of the management of the city of the Ventura County. Mr. Turner is given a task and Mr. Turner does his job or he doesn't keep his job. And a lot of the animosity directed at Mr. Turner, in my opinion, is wrongfully, directed. There's others that are giving direction and giving orders. I do not believe Mr. Turner is a rogue cowboy doing what he wants to do. As long as this has been going on, it has been a tremendous improvement from what initially was stated. And some of the people that are speaking tonight, I had never seen them to come to the other meetings when we were meeting in face to face. A lot of good comments tonight. I think it would be wise to try to go back and do something. Not knowing, as Mr. Thomas said, I've not had the deal of going on military bases. His point with the sticker, I think he made a good point. But this number 39, there are a lot of issues and a lot of points that have been made. I think it's worth going back and trying again. But to all the speakers, I think you're looking at the wrong guy as the bad guy in this scenario. The man is doing his job. He's taking orders. I have no idea how his indigestion is right now, but he's taking orders. And some of you seem to have forgotten that. Thank you for the job you're doing, Mr. Turner. And thank you, Madam Chair.
Thank you, Commissioner Perillo. Any other commissioners at this time? I wanted to take this moment, if there's no others, to really look at, is there someone else?
Chair Long,
Yes. Please go ahead.
I just want to agree with Commissioner Perillo about Mr. Turner. He did walk into a situation. I've only been here. This is my second meeting, I think. So I see what he's been trying to do. It's taken a long time. He inherited it, and I think this is a way to go forward, though, to continue working to tighten things up, make some adjustments, and obviously we're looking to Mr. Temple for the help with that, and not necessarily Mr. Turner, who is not a lawyer, I think. So I agree with you, Councilman Perillo. Thank you.
Thank you. Walter Calhoun, are you trying to speak? No? Okay. You are? Okay, try and mute your microphone then. I see you trying to push the buttons. I can't hear you. Can't hear you. There you go.
Okay.
Okay, go ahead.
I'm sure that was my fault. I apologize. Well, my sentiments, and I'll be brief also, echo pretty much what most of my constituents have said. But I think the speakers in the audience have been extremely persuasive. I don't understand all the legalese involved tonight, certainly, and I've read some of these letters 2 or 3 times, and I get more confused every time I read them. However, I have been around the airport and a supporter of the airport and the people that have supported it for longer than I care to say. And when it comes to Kip Turner, their words can't express the kind of honesty and objectivity and desire that he's put forth in this job in a fashion to try to improve this thing. And it is drastically improved. I think it goes without saying that this particular time with the epidemic, pandemic going on, couldn't be a worse time to have something like this discussed and really, and all the problems realized. I think we need the people there, in there at the place to do so everybody understands where they come from, although the language is becoming more clear. So anyway, to just consolidate what I'm trying to get to, I think at this point we have no choice but to postpone this and give Kip if he'll do it, give Kip an opportunity to refine these just a few. I think 39 seems to be the big one. I know on the 21st a year ago, that was, I believe, the only one we had to resolve. But there's been some deficiencies have reflected on that since then. And if we could just postpone this long enough to get these obvious problems or misunderstandings, let's say, worked out, I would be much more in favor of it and to go forward at that time. Thank you.
Thank you, Commissioner Calhoun. Commissioner Lopez.
Thank you, Chair. I think everyone has already kind of said, said what we're all thinking, and certainly appreciate all the work from Mr. Turner and Mr. Temple. And sometimes what I've seen, at least from both sides, is there's a lot of space for interpretation that I think would create some of the issues that have been raised, and I think that's definitely a concern to protect the county, to protect the airports, as well as the tenants there. But sometimes there is maybe information that we haven't received, or some details that are missing as to how or why we got to this point of where item 39 is at. So just generally wanted to ask if there was something more that either Mr. Turner or Mr. Temple can provide. But I also just wondered if there were in this process, and I know was very extensive, I mean years long, if there were other samples or any other lease documents that could be a point of reference, or that were a point of reference to address this issue that I imagine might be also an issue in other areas. Thank you.
Thank you. Kip, did you want to respond to that, or?
Well, I mean, we've used a ton of research to get to where we are today. We've used airport leases all over the country. Any well-written lease that we thought was a viable lease for receiving input on and taking examples that would be beneficial to our airports, we used and discarded the ones that weren't. So there was a lot of energy and effort put into where we are today. So I think that was the question, if it was, Ms. Lopez.
Yes, thank you very much. And I would like to, I don't see any other commissioners on it. Okay, so I really wanted to talk to the point of, Kip had stated this has been going on for 7 years, and that was such a process. It was very much a stop and go portion. As you see this chart on the left, the current lease, there was a lot of things that most people did not agree with. And we hit the brick wall, and we had to come back and really look at the lease. We had Todd McNamee, rest in peace, that had cancer. There was a whole situation with that. There was delays in this hangar lease that came on. And then we were able to fortunately hire Mr. Turner here, that took this wild beast by the tail and is trying to reformat it. And there's a lot of emotions, as these are ownership of our hangar owners. So I appreciate the emotions, but I want to make sure that I respect Mr. Turner in the job that he is doing. And I really appreciate, if you look at this new list, and I know we've all pushed and prod and tried to figure out how to do it, we've really accomplished a lot on this new lease. I do agree with my commissioners. I have only 2 items, which is amazing because I had this lease a long time ago redlined everywhere. To be able to say there's 2 items, which is item 10, because I know, speaking to many people around the different airports, that you don't always drive your one car in. And it might be a different car and you trade out, and then you have your wife coming in a second car. So having 2 that they could drive in, I would like to see how that is, that we can figure that out. If it's either a pilot program that we do or pull it out separately, have some instructions, I would like to have that come back, because Ventura County is a family. We're a family airport. I know everyone's saying it's, we're a big airport. We're family. Ventura County, we all stay here. We all live here. And I want to make sure we're working together. And that's just a little thing that I think we can do. And then the second one is 39. Those 39 and 40 was kind of put back together, and appreciate Mr. Temple in all of his understanding of the issues at hand. I do believe that there are a couple of things that are vague there, and Scott Bear was talking about just putting in if the lease was a criminal conviction. I don't know how that sits with Mr. Temple. I would like to see 39 just go back and see if there's something that we can do to make sure that item B and D do not put our employees or our hangar owners in a he said, she said. I think that's extremely vague. So if I would like this lease to come back with those 2 items cleaned up. I appreciate the commission that met on the 1st, and it was a 6-1 to not move ahead, and I appreciate their insight as well. And again, Mr. Temple, thank you so much. I'm sure you wish this was done 7 years ago. Really easy, write up a lease, and there's a lot of moving parts to our hangars, and so appreciate the review of this lease. And I would like to see just those 2, the 10 and the 39, and I think that we could bring it back pretty quickly and get that done, and then be able to move it into the Board of Supervisors. Personally, I think that if we don't fix this right now, it's still going to follow us to the Board of Supervisors. And then you have 2 supervisors that sit on these boards right now, and you've heard from us as well. So I want to give you my thoughts on that. So with that, I know those were a lot of words. Is there a motion on the floor?
Can I?
Yes, Bill.
Well, I would like to make a motion that the Aviation Commission went for 90 days. I would recommend a 60-day maximum, because I think that this can get fixed inside of 2 months. And if it was ready to come the next time we're meeting in April, I'd be happy to see it in 30 days. But I think that we really would like to see, and for my motion, I would move that we take the item 10 part on the decals and put that aside for the moment and come up with that in a separate meeting, and see if we can get Cohota and the airport and maybe some of the smart people who spoke to see if we can change the words on those 2 or 3 sentences on 39.
And so that would be for the Camarillo Authority?
For the Camry Authority, I'm sorry.
And I would second that. Are there any discussions?
Oxnard, do I hear any discussion, please?
I'd support that, Mr. Calhoun.
Okay.
Thank you, Bert. I would do the same. I'm support for that. Could we have
okay.
A roll call?
So for Camarillo, it would be Bill Thomas. It was a first, and second by Kelly Long. And for Oxnard, it would be Bert Perillo was first and Walter Calhoun was the second. Just Anna, just to make sure you had that.
Thank you very much. Would you like a roll call vote for each authority?
For Camarillo, yes, please.
Supervisor Long?
Yes.
Supervisor Ramirez?
Yes.
Vice Mayor Molche,
Yes.
Councilmember Santangelo,
Yes.
Bill Thomas.
Yes.
That motion passes unanimously. For Oxnard, Chair Calhoun, would you like a roll call vote?
Yes, please.
Supervisor Long,
Yes, and for both my votes, I want to make sure that we're directing our airport director and Mr. Temple to work with the Coyote and also other hangar owners, or we have some specialists that spoke today.
thank you. Supervisor Ramirez,
Yes.
Councilmember Perrello,
Yes.
Councilmember Lopez,
Yes.
Walter Calhoun.
Yes.
That motion passes unanimously.
Thank you, and appreciate, there were a couple I had written down. It was Barry Groveman, Leslie McAdams. If you have any, if anyone has any example of a 39 to suggest, please submit it to our email. Appreciate it. And thank you so much for everyone, your input. Greatly appreciated. Kip, staff have any questions on that one?
No, we don't have any questions, but as we stated to the commission, and I stated in the opening comments in my presentation with you, and I'll conclude with the same. Everything we've talked about tonight, staff had already received, considered, and exhausted. So I'm not really sure where this takes us, because at the end of the day, I'm a county employee, and it's my job as the director of airports to recommend something to my employer that is what we believe to be where we need to be, and that's where we are. So we're receiving your feedback tonight, and we'll try to figure out what that means going forward. I'm not sure.
Okay, thank you very much. Just wanted to make sure everyone was clear. Next item is our proposed change of the meeting time. So we asked Kip to come back with the meeting times. We know that the location is now going to be changing. Before there were some requirements where the city of Camarillo was not available till 7 o'clock. And so we were looking on these items. Kip, I'll turn it over to you.
Yeah, I'm not sure there's a whole lot I can add. I'm getting a little feedback, sorry, but I'm not sure there's a whole lot I can add, but we do have some proposed times here that we think might be what your authorities would be thinking would be something you would want to consider. Of course, these are just proposed times that we've included here for discussion. Obviously, the item is open for your discussion and your suggestions at whatever might please the boards.
Okay, so Kip and I met earlier and he said, well, what do you want? And I said, well, I don't know. Can you guys do it at 5 or 5:30, 6? This is also in thought of our staff that is working overtime to be at our meetings and trying to understand their need as well. And so Kip, is the staff, they would show up at any time we ask, but is there a time that was more suitable?
Yeah, 10 a.m.
Well, that doesn't work because of public comments and all the other stuff. So we need a majority that can be here. Actually, we need all of you here. And so I wanted to see is 6 o'clock, if we start an hour early, would you be able to meet it? I don't know everyone's schedules. Looking for some direction from everybody. Mr. Thomas.
So for Kip, let's assume COVID goes away and we start having these meetings at the Oxnard Airport in the facility there. Is there any transportation timeline that works better for you and your staff? Since I'm retired, I can disregard myself, so I can meet whenever you want. But is one of those times better, assuming you're going to have to bring your staff from Camarillo to Oxnard?
Well, luckily, since I started 2 years ago, we started manning more staff at the Oxnard Airport. So for example, I share an office there 2 days a week. The deputy director shares an office there 3 days a week. So now we have senior leadership there 5 days a week. We brought on another ops supervisor. So now we have more supervision in the ops department. We've got our maintenance supervisor spending more time there. And then we've got a full ops and maintenance crew that work there. So really our staff is more diverse now between the two airports. The only thing I might add is, but when we do go back to the ability to have in-person meetings, right now, the terminal building is where we're contemplating doing that. And right now, I believe the rental car services, which is the only venue in there right now, of course, and of course, this would change upon the arrival of new airline service. If we were to see airline services, the venue would have to change, period. But until new airline service does come back to Oxnard, the only activity going on inside the terminal, the rental car facilities, and they conclude their business operations, I believe, at 6 p.m. But I do have some smarter staff on the line that can correct me if I'm wrong. But so if we're trying to keep the focus on that, we would have the terminal uninterrupted, if you will, at 6 p.m. So maybe that's the time to consider. If you're not going to go to 10 a.m.
6 p.m. is an earlier than 7. Would everyone be able to meet at 6 o'clock? Bert?
You're muted, Bert.
Thank you. I've been appointed to an organization called Ventura Council of Governments. They meet at 5 o'clock and they go till 6:30.
Oh, okay. So you're 6:30. So that's 7. Councilmember Milche?
I was gonna say, I can meet as early as 6, and usually for me, no earlier. I work at 6 a.m. to 5 p.m. job, so I'm not usually able to get off till about 5 o'clock, and then I gotta travel. I'm gonna go to Oxnard, so 6. I'm fine with 6, 6:30, or 7 personally. I would just simply prefer nothing earlier than 6.
Okay, Councilmember Santangelo. My tongue is tied today. I'm sorry.
Not that hard.
No, it's not. I've been Zooming since 8 o'clock this morning.
I work every day as well. And I generally don't get off until 5 in Camarillo. So, 6 would be the earliest for me.
Okay, and was there someone else's hand that was up? I didn't see that. Eugene, did you have a comment?
No, I was just interested in what the survey showed. I'm available at any time, but that was a survey that went out, and I just wondered what was the result of the survey.
Kip, did you hear back from anyone?
Well, we're not able to do a survey because of, is it California Code or Brown Act? I can't remember which one it is, but it would be incorrect for us to do a survey and retrieve results from a survey and then feed that back to anyone. So we were not able to do so.
Okay, so what I'm hearing from most people can hit 6 o'clock, except for Bert, who's a 6:30. So a half hour sometimes is a lot for our group to start there. My concern also is our public comments to make sure that they have it. Are there any public comments on this item? I have Joe Leckman with his hand up. Is it for the meeting time? I guess it is. I will open this for public comment. Let's hear from the public. Joe Leckman, you have 3 minutes.
Hi, I would just say a lot of the pilots and friends that I know that use the airport that take an interest in these things, they have day jobs too. And it would be pretty tough to make a 5 o'clock meeting because most people just don't have the liberty of taking off work early. I could potentially see 6, but if we're also moving it to Oxnard, I would say probably 6:30 at the latest. And hopefully they can let us bring dinner because these meetings sometimes last a while and there's no time to eat dinner before a 6:30 meeting for a lot of us. So I know we don't like to stay really, really late, starting at 7, but it does give us, the members of the public, the broadest opportunity to participate.
Thank you, Joe. Thank you for your comments. Scott Bear? Go ahead, Scott. You're on mute. There you go.
Simply put, and I'll be short, which I'm sure everybody will appreciate, Joe Leckman nailed it. I mean, a lot of us have day jobs. I know someone who spoke tonight works in Century City and commutes out to the Calabasas area. So really anything earlier than 6:30 is, especially in Oxnard, for those of us who live towards the east, would be tough. So I'd recommend, my view is I'd recommend nothing earlier than 6:30. Thank you.
Thank you. Okay. Bert, would you be able to make 6:30? I've just been on this.
Especially if
with you.
there's Zoom.
Okay.
If there's Zooms, for sure. For sure. I don't know. Maybe I can swap with another councilman on the thing, or some other councilman can take this seat. I'm not sure. I'll accommodate the group, whatever I can do.
Thank you. Well, it's sounding like 6:30 everyone could do, and even a half hour. I'm just in thought with staff. I know all of you working day jobs. We all have day jobs. Or whatever we're doing. Would anyone motion to entertain the 6:30? It's an open dialogue.
I'd move it. I'm okay with any time, but I live in Oxnard. It's not a problem.
Okay,
But,
so
whatever the majority wants, and it sounds like it's 6:30. I make that
Okay.
motion.
that's what I'm hoping.
And
So I would
I'll
take
make
that.
I'll make a second to 6:30, and I think we give it a try as we switch to in-person. It may be that we need to go back to 7, but at that point, we can make that decision then.
That's very true. This is flexible. We can change it back, just like we're changing location. Okay, so Oxnard, Walter? I'll motion to move the time for the Oxnard till 6:30 if there's a second.
Second.
Awesome. There's a first and a second. All in favor for Camarillo, say aye.
Aye.
Any noes? Abstention? Okay, 6:30 it is. Motion is approved unanimously. And Walter? You're on mute. Your voice is muted, Walter. You have to unmute. You're sorry. It's that small button. I
think I'm on.
You're on. Go for it.
Okay. I'm in favor of 6:30 is fine.
Okay, so you have a first and a second. First by Supervisor Long, second by Supervisor Ramirez for your motion.
All those in favor?
Aye.
Aye.
Hearing none opposed? Motion
Yep.
carries.
Great,
you.
unanimously. So the next meeting will be at 6:30. And thank you very much, Kip, for putting that on our agenda for today. I really appreciate that. Next item we have is our director's report.
Oh, in anticipation of what we thought would be a long meeting tonight, it's very short, so you'll be glad to hear that. Really just 2 items to touch on real quick. We're looking to, you should be receiving an invite soon for a grand opening ceremony for the Northeast Hangar project that we've just completed. And the second item is I want to remind everyone that we have our first workshop plan for the master plan study, where we look at the future of both of our 2 airports for the next 10 to 15 years. That workshop is planned for May 13th. And with that, I have no further comments for the director's report, but I'm happy to field any questions.
I would like to just say thank you for being on site during the weekend for the accident that happened. I'm very happy that the plane was taken care of and that there were no injuries. Also appreciate the email out to all the commissions and authority, because that was important for our community that calls us and says, hey, did you hear what happened to the airport? So we really do appreciate the heads up on it. So thank you very much. All right. Anyone else?
Question.
Questions? Go ahead, Bert.
Yes. Director Turner, there was somewhat, it sounded like an allusion to potential commercial flights coming in. Is there any new news on that for the board?
Nothing that we can report. We do have airline interest in the Oxnard Airport as we speak, but we're still working to see what that looks like and see how that unfolds, and then we also really are interested in trying to get more input back from the master plan study to see, what that equation looks like long term. So, yeah.
Okay, thank you very much.
Thank you, Commissioner Moshe.
Thank you. Director Turner, on the master plan, you said the workshop. Can you repeat the date for the first workshop? May something?
Yes, absolutely. May the 13th.
13th. And as of right now, do we plan on that being via Zoom unless we resort?
Yeah, it'd definitely be at worst or best a hybrid, but yeah, it'd definitely be out there for the world. Yeah, it'll be definitely a platform you can join in from anywhere in the country.
And can you? I have one or two follow-ups, Supervisor Long. What is the plan for the workshops? I know that the master plan has been, at least when it comes to communicating with the public and different stakeholders, I know that's been kind of delayed because of the coronavirus. So now that hopefully we're on a path to some sort of normalcy, what is the plan going forward when it comes to these workshops and engaging the different stakeholders?
Absolutely, great question. Thank you. Yeah, it's the the same that you would expect in any public workshop. So we'll be reaching out with all kinds of announcements as we lead up to the 13th of May, inviting different groups, inviting the public in general, all of our county members around the county. But we're wanting as much input and as much participation as we can possibly gather for this, because it truly does set the playbook, if you will, for the next 10 to 15 years for our two airports. So it's really vital that we hear from all segments of the county. So we're already working behind the scenes to try to solicit, leadership groups and business organizations and that kind of thing. And then, of course, as we get closer to May 13th, we'll start publicizing in more general public announcements and general public advertisements and things like that, seeking people to join us and participate.
I know the original master plan called for an advisory committee of different stakeholders. It was like no more than 20 people. Is there I haven't heard anything about assembling such a advisory committee. What's going on with that? And is there one advisory committee for the master plan over both airports, or is there going to be a separate advisory for each airport master plan?
Yeah, good question. So the advisory committee is for the master plan study itself. The master plan study is was originally primarily funded for the Camarillo Airport. However, we sought further participation from FAA to allow us to include the Oxnard Airport. And it's a very typical thing. We've just completed part of a master plan for Oxnard already. They're just staggering years apart. But we wanted to look at both airports collectively as a system of airports. So this is more of a system plan study, if you will, with the first focus on Camarillo, just because of the way the funding lined up for Camarillo first, and again because we were just wrapping up other elements like this on Oxnard, but we wanted to pull those elements back into this study to look at it as a system. So it's a little bit of both. But so, yeah, there's definitely the focus on both, on how we grow together and how the two airports feed off each other and how they help each other and how they help our community more so. And that's what we're looking to try to accomplish there. And what was the other part? The Planning Advisory Committee is one committee for the study. So it's going to comprise members of both Oxnard and Camarillo and obviously other segments of the county as well.
That hasn't been assembled yet, though, right?
It's being assembled. It's the work's underway behind the scenes on that now, and it's a non-voting committee. They don't have any control of the outcome any more than the general public that participates. It's just a sort of a committee, if you will, to to help bring more constituents to the table, and it's really more of a cheerleader committee. But yeah, it's being formed.
When will we know who's on that committee?
Well, pretty soon. Actually, we're working on it now, so I can probably report back on that next month.
Okay, thank you.
Okay, Commissioner Hudson, Mike.
Maybe on mute.
We can't hear you, Mike. You're unmuted, but there's no volume that we can hear. We cannot hear your sound. No, can't hear you. So I'm sorry. We cannot hear what you're saying, and I'm not a good lip riser. It's okay. Thanks. Commissioner Perillo.
Yes, with respect to this committee, this oversight, is there a selection process based on applications? And if there is an application, where do people get an application? Was it an open application? Is it an appointee? Can you give us a little more, give me a little more information? Because I have residents in my city that are very interested.
Yeah, absolutely. And we're like I said, we are working behind the scenes now to form that planning advisory committee. And again, I want to stress that the committee has no powers over the general Joe person that walks up to the public to participate. It's really more of a, this is my term, but more of a cheerleader committee to gather up more people to be participating in the study and to, to help make sure that we're trying to address and talk about the topics that affect our communities and so forth. But at the same token, we do the same thing at the public workshop. So it's really just an added part of that. But the committee itself, I'd rather report back on how the formation of it is coming. But I can assure you that includes a good representation from the city of Oxnard, a good representation from the city of Camarillo, a good representation of leadership throughout the county, and a good representation of our businesses involved in the county and other groups that may be interested.
Okay, thank you.
And Commissioner Lopez, did you also have a question?
I did, but Commissioner Molche asked my question, so thank you.
Perfect. Anyone else? I'm sorry, Mike's mic can't work. Okay. Then we also have our reports.
Staff has nothing other than what's in the packet, but we're happy to field questions.
Does anyone have any questions on the reports? I would appreciate, I just want to say thank you. There were several emails in regards to noise of planes, Mrs. Dow and so forth that you handled. Appreciate being able to get to that quickly and not have to wait for our meeting. So thank you very much. Any of those? All right. We have our list of correspondence. Any questions on our correspondence? Seeing none, hearing none. Then we are adjourned. Please note that on your calendar, Thursday, April 8th at 6:30. So we will be here on the same Zoom channel at 6:30 and really appreciate everyone's participation. I know it's late tonight, but it was some good work today and really appreciate it. So have a good night. Stay safe.
Chair Long,
Yes.
I think we
Yes,
missed
Bert.
number 10. I think we missed number 10.
Oh, I thought you're right. It was at the end. Apologize. Authority comments, please go ahead, Bert.
Yes, there has been a tremendous amount of interest in my community with respect to the traffic patterns of the small planes that are taking off and circling in areas of Oxnard. There is a movement growing. They're working with neighborhood councils and the organizations throughout that. I want to bring it to your attention. They may have been here. They may have put the letters in, but it is not going away. And there's concerns that if there is a possibility that there could be a review, because some of the maps and some of the aerial photographs show areas where the planes turn. And at the time when the aerial photographs are in there, they show no homes in those areas. And there is a tremendous amount of homes that have been built up in those areas. So they're wondering if there's an opportunity to do something different. I appreciate everything that Mr. Turner has done. in responding to these things, but these groups are going to want an answer, and they may want to be able to make a presentation. I'm not sure yet, but I'm carrying their message. Thank you, Chair.
And in that particular regard, even though I'm Camarillo, not Oxnard, I know that there's efforts being made for the school board to take land on the north side of the runway and fill it in with houses there. So for the city of Oxnard, you guys got a real dilemma. Are you going to protect the ones to the south that are already there, or are you going to let it expand into the north and have them both angry at you?
Very good question.
Can I add that
Go ahead.
I've been contacted by people at Channel Islands Neighborhood Council. I think that's what you're also speaking to, Commissioner Camarillo, who would actually want to make a presentation. It has to be an agenda. I don't know if that's a possibility or they should just do it in public comment, but something I think we need to hear them out.
Thank you for that comment. I believe Kip Turner and Anna received the email from them as well. So thank you. And you're right, airports, we have to watch out for encroachment. Just like the Navy base, we have to be able to have partners with our cities to make sure that our airports can still function, or we'll be Santa Monica and we'll be shut down. So we need to be our own advocates, definitely. So, which would be, yeah. So any other comments from commissioners?
So
Seeing
just
none. Yes.
just half a second. One of them is that we're in full planning mode for the Camarillo Air Show in August. We're probably looking better than 50-50 now. Last month it was 40-60. So I'm getting encouraged that we might actually be able to pull it off. I'll be talking with my friends on the Camarillo City Council here shortly to see what can we do, because it was easy to make the decision when there wasn't going to be one, but now I'm hopeful. And then I was going to ask Kip real quick, is there anything updated on the Cloud9 as far as pulling permits or anything? I knew that there was stuff mentioned in the project status, but it just said soon.
Yeah, so we don't normally try to be collected of information and report on third-party projects, but I do know they're making progress. But I would direct you to Cloud9 personnel for their updates on that.
No, that's fine. That's fine. I just saw it there and thought I would ask.
Thank you very much. And as President Biden stated, he wants vaccines by May 1st. You might get your wish, Bill, that we'll be able to get it. I just want everyone vaccinated, so that's great. All right, if that is it, we are adjourned to the next meeting. Thank you for all the good work and your service tonight. Appreciate it all. Thank you.
Thank you.
Good night.
Good night.
Everybody.